Fair Labor Standards Act by Logan, Trapp, Dalton, Earhart, Thomas Porter, Aaron Daniel, and Brady Sartain. Logan did the full intro, and San Antonio vs. Garcia. Dalton did the FLSA section, Encino versus Navarro. Thomas did Christopher versus SmithKline. Aaron did Auer versus Robbins. Brady did Sendifier versus U.S. Steel. The Fair Labor Standards Act was passed in 1936. It was regulated by the Department of Labor, regulates minimum wage, amount of hours, overtime pay, etc. This is the backbone of our workforce. The important cases that we found was Encino Motor Cars versus Navarro, Christopher versus SmithKline Beecham Court, Auer versus Robbins, Garcia versus San Antonio Metropolitan Transport Authority, and Sendifier versus U.S. Steel Court.
The Fair Labor Standards Act establishes a minimum wage, time and a half overtime pay, record keeping, and minor employment standards. This law affects employees in the private, federal, state, and local private sector as well as the government. Covered non-exempt workers are entitled to a minimum wage of no less than $7.25 per hour. Overtime pay at a rate not less than 1.5 times the regular rate of pay is required after 40 hours of work in a work week. The FLSA initially established a 25-cent hourly minimum wage, but of course it has changed over time today where it is now $7.25. The law originally debuted a 44-hour work week limit, which was later reduced to 40. The act also banned businesses from employing workers younger than 14, with a few exceptions. On June 25, 1938, President Franklin D. Roosevelt signed 121 bills. Among these bills was a notable law on the nation's social and economic development, the Fair Labor Standards Act of 1938. There was lots of judicial opposition to this act, but it did make it through, as well as it did make it through the Great Depression. Encino Motor Cars versus Navarro was a Supreme Court of the United States case addressing overtime pay. Specifically at issue was whether automotive service advisors are eligible for overtime pay under the FLSA. The case had been heard twice by the Supreme Court. In the first pass, the court vacated a previous decision by the Ninth Circuit Appeals Court, which relied on interpretive ruling of the FLSA provided by the United States Department of Labor. Encino Motor Cars argued that the plain language and structure unambiguously exempt service advisors from the FLSA's overtime requirements. Navarro argues that the plain language and structure clearly do not exempt service advisors from the FLSA's overtime requirements, and that Congress' intent enacting the exemption in the FLSA as a whole support this interpretation. From a policy perspective, this case is significant because a decision favoring Navarro could force dealerships across the United States to alter their payment systems for service advisors. In 2012, a group of 5 individuals employed as service advisors, Navarro, at Encino Motor Cars, Encino, filed suit against Encino for violating the FLSA. Among other things, Navarro's claim is that Encino failed to pay them overtime wages. The district court dismissed the claim because it concluded that service advisors fell within an exemption to the overtime requirement found in the FLSA. On appeal, the Ninth Circuit overturned the ruling. The Ninth Circuit claimed that the Department of Labor's interpretation was reasonable. Although Encino lost at the Ninth Circuit, they would appeal to the Supreme Court. The Supreme Court reviewed the case the first time, but then sent it back to the Ninth Circuit. The case was re-examined, but again, the court at the Ninth Circuit again came to the same conclusion. Encino would lose again, but also appeal again, sending the case back to the Supreme Court for a second time. Results from both Supreme Court hearings of the case concluded that in the first time, it was a 6-2 decision. The case went back to the Ninth Circuit, and Encino appealed a second time. The second and final time, the Supreme Court would hear the case, but it would result in a 5-4 decision. This time, the Ninth Circuit was reversed, and the service advisors were ruled exempt.
Michael Christopher was an employer of SmithKline Beecham Corporation. He was a outside salesman who was labeled as exempt from FLSA overtime pay status. The FLSA classifies employees into two categories. They're either exempt or non-exempt. Non-exempt employees can earn half-time or time and a half overtime pay, and exempt employees do not receive any overtime. Michael Christopher, who worked as a pharmaceutical sales rep for GSK from 2003 to 2007, averaged about 40 hours a week working face-to-face with physicians, trying to get them to prescribe SmithKline Beecham drugs. The other part is that, in addition, he worked 10 to 20 hours a week conducting work on the phone and attending pharmaceutical events. His compensation was around $70,000 a year, and it did not include overtime pay. But when you add in the 40 hours a week he worked along with the 10 to 20 additional, it was much more than 40 hours a week on average. So the case first went to the district court, and the ruling was very quickly and stated that Mr. Christopher worked as an outside salesman, and for that reason, he's exempt from FLSA regulation. So GSK won. The case then went on to the Court of Appeals, who confirmed the district court ruling, and that was another win for GSK. However, shortly after that, the Department of Labor submitted an amicus brief stating that their interpretation of the FLSA rules was that outside salesmen, specifically pharmaceutical salesmen, are non-exempt from overtime. And at this time, that's when the case then went to the Supreme Court. Now, the FLSA was passed, over 70 years before this went to the Supreme Court, which is why the Supreme Court took special notice to the case. They were equally concerned with the exempt and non-exempt status of outside salesmen as they were the Department of Labor's authority to make the claims they did in the amicus brief. The Department of Labor was well aware for over 70 years that outside salesmen were exempt from FLSA protection. And in the eyes of the Supreme Court, if there was ever a time to give their own interpretation of the FLSA rules, it should have been within the 70 years prior to the case coming up. So the Supreme Court basically did not consider the amicus brief from the DOL at all. And furthermore, they ruled in favor of GlaxoSmithKline. So GSK won, and Michael Christopher was not awarded any overtime pay. Now, why this was so important is because for SmithKline, this was like a multi-million-dollar issue. They employ thousands and thousands of pharmaceutical sales reps. So the amount of overtime pay that they were, or back pay that they would have had to give had the salesman been labeled non-exempt would have been hundreds of millions of dollars, and it would have bankrupted GlaxoSmithKline. Looking even farther out, though, this was a global issue because pharmaceutical sales reps around the world would have had to have been awarded back pay. So this was a multi-billion-dollar issue.
All right, so I did the R versus Robbins case. I'm just gonna give you a brief overview of what the case is about and like how it came about. So the case was argued on December 10th, 1996, and it was decided on February 19th, 1997. So just a few months. The case presents the question of whether the Secretary of Labor's salary basis for determining an employee's exempt status reflects a permissible rating as it applies to the public sector of the employees. The court also considered in the case if the Secretary has responsibly interpreted the salary basis test to deny an employee's salary status. Petitioners in this case are the sergeants and lieutenants of the St. Louis Police Department,
So basically they're arguing that they should have been paid overtime pay when they weren't. This case was brought up against the St. Louis Board of Police Commissioners, who is overseeing whether they get paid overtime pay or not. The officers were wanting to receive the overtime pay to them that was owed to them under the Fair Labor Standard Act. The Board of Police Commissioners stated that the petitioners were not entitled to pay because of the exemption provided for the executive, administrative, or professional employees. So the problem here is that these lieutenants and sergeants are under salary-based pay, so they are kind of exempt from overtime pay. For example, I'm an hourly paid worker at work, but the lady I work with, she's a salary, so anytime that she has to stay later, she does not get paid overtime pay, but I do if I stay later. The district court found that the petitioners were paid on salary basis and that most, but not all, satisfied the duties of standard. According to the approach, the exempt status requires that the employees be paid on a salary basis. Since the salary basis test is something that is managed by the secretary in this situation, is under his control. So in the end, the Court of Appeals rejected the petitioner's approach, in which they said that there were mere possibility of an improper deduction in pay that does not defeat an employee's salary status if no practice of making their deductions exists. Since the salary basis test is something that is headed by the secretary's own regulations, since interpretations of it is under his control. In the salary basis test, that's a series of stipulations that may exempt an employee from being eligible for overtime pay. The salary basis test says that an employee must be paid a predetermined fixed salary, and this means that their salary cannot go up or down based on the quality or quantity of work. So the main question in this case was whether sergeants or lieutenants should be paid for working overtime according to FLSA. In a unanimous decision, the court ruled that the sergeants and lieutenants are exempt as salary employees. The justices rejected the argument that the possibility of suspension without pay moves the officers out of the exempt category.
Garcia versus San Antonio Metro Transit Authority. In 1938, when the Fair Labor Standards Act was first passed, there were a few businesses and employees that did not have to comply with the FLSA. These were private transit and government employees. There were a few cases with these businesses where it was ruled that Congress had the power to enforce the FLSA laws, and a few that did not. In the Maryland versus Ritz case, it was ruled that Congress did not have the power to enforce FLSA laws, and in National League of Cities versus Ussery, it was ruled that they did not have the power. Before 1976, the San Antonio Metro Transit Authority paid its employees according to the FLSA. The San Antonio Metro Transit Authority followed the National League of Cities versus Ussery, which decided that Congress did not have the power to enforce the FLSA. Joe Garcia and some of his co-workers did not think this was right, and they decided to sue the San Antonio Metro Transit. They wanted to recover their pay that they were owed according to the Fair Labor Standards Act. This was a very complicated case where there was a lot of gray areas, since there were two cases that were very similar that had two different decisions. This case went all the way to the Supreme Court. The final verdict was that it was a 5-1 decision that Congress had the power under the Commerce Clause to enforce the Fair Labor Standards Act on government and state employees. In this case, it is one of the most important cases related to the Fair Labor Standards Act. In the case of National League of Cities versus Ussery, it ended up reversing the original decision that Congress did not have the power to where they did have the power. This stopped other state and other government employees from being taken advantage of, and it protected the future of the workers in other government or other state jobs to comply with the Fair Labor Standards Act.
In Sandifer versus United States Steel Corporation, this case presents a question. does changing into required safety gear constitute changing clothes under the FLSA? This case began when workers at the U.S. Steel Corporation filed a class action lawsuit against the company, arguing that the FLSA requires the company to compensate them for the time they spent changing in and out of their work clothes. Under the FLSA, employees are normally compensated for the time they spend changing in and out of their protective clothing if it's something that's required by law or their employer. However, in 1949, Congress passed Section 3.0 of the FLSA, which prevents employees from getting paid for the time they spend changing clothes, either through a collective bargaining agreement or through company policy. This section caused an argument between the U.S. Steel Company and its employees on what the definition of changing clothes was. The employees argued that an item should not be considered clothing if it is worn specifically to protect against workplace hazards. The company argued the opposite and wanted the entire work uniform to be included as clothing. The court found a middle ground in this argument and decided that items like boots, flame-resistant jackets and pants were all considered clothing, but items like earplugs and safety glasses are not. They held that the majority of what the employees considered to be equipment was actually considered to be clothing. In the end, the court ruled in favor of the U.S. Steel Corporation and stated that they were not required to compensate their employees for the time it takes them to change in and out of their work clothes. In conclusion, the Fair Labor Standards Act is important because it protects both employers and employees and prevents them from taking advantage of each other. This act provides important regulations in the workforce, which provides workers with the leverage such as minimum wage and overtime pay. The law gives workers power and also holds employers accountable if they are not following through with fair labor contracts. Every case covered in this PowerPoint is an example of why the FLSA is important.